This is the case of Shawaram versus Philippine Airlines. In this case, Shawaram, the plaintiff appellee, was a paying passenger on defendant's aircraft from Zamboanga City bound for Manila. Defendant appellant is a common carrier engaged in airline transportation in the Philippines, offering its services to the public to carry and transport passengers and cargoes from and to different points in the Philippines. On November 23, 1959, plaintiff checked in his baggage. The suitcase was mistagged by defendant's personnel in Zamboanga City as IGN for Iligan instead of M&L for Manila. When plaintiff Shawaram arrived in Manila on the date of November 23, 1959, his suitcase did not arrive with his flight because it was sent to Iligan. So he made a claim with defendant's personnel in Manila Airport. The suitcase belonging to the plaintiff arrived in Manila Airport the next day. However, his transistor radio 7 and Rolleiflex camera were missing. Accordingly, Shawara made demand for these two items or for the value thereof, but the same was not complied with by the defendant. The trial court believed that these two items were really in plaintiff's suitcase and defendant should be held liable for the same by virtue of its contract of carriage. There is no question that the appellant is a common carrier. As such common carrier, the appellant, from the nature of its business and for reasons of public policy, is bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by it, according to the circumstances of each case. It having been shown that the loss of the transistor radio and the camera of the appellee, costing 373 pesos, was due to the negligence of the employees of the appellant, it is clear that the appellant should be held liable for the payment of said loss. However, it is contended by the appellant that its liability should be limited to the amount stated in the conditions of carriage printed at the back of the plane ticket stub, which was issued to the appellee, which conditions are embodied in Domestic Tariff Regulations Number 2, which was filed with the Civil Aeronautics Board. The appellant maintains that in view of the failure of the appellee to declare a higher value for his luggage and pay the freight on the basis of said declared value when he checked such luggage at the Zamboanga City Airport, appellee cannot demand payment from the appellant of an amount in excess of 100 pesos. The issue here in this case is whether or not the pecuniary liability of the defendant can be limited based on the provisions of the tariff regulations filed by defendant appellant with the Civil Aeronautics Board and the conditions of carriage printed at the back of the plane ticket stub in relation to Article 1750 of the Civil Code. The court ruled in the negative. In accordance with Article 1750 of the Civil Code, the pecuniary liability of a common carrier may, by contract, be limited to a fixed amount. It is required, however, that the contract must be reasonable and just under the circumstances and has been fairly and freely agreed upon. The requirements provided in Article 1750 of the new Civil Code must be complied with before a common carrier can claim a limitation of its pecuniary liability in case of loss, destruction, or deterioration of the goods it has undertaken to transport. In this case, the requirements of said article have not been met. It cannot be said that the appellee had actually entered into a contract with the appellant, embodying the conditions as printed at the back of the ticket stub that was issued by the appellant to the appellee. The fact that those conditions are printed at the back of the ticket stub in letters so small that they are hard to read would not warrant the presumption that the appellee was aware of those conditions such that he had fairly and freely agreed to those conditions. The trial court has categorically stated in its decision that the defendant admits that passengers do not sign the ticket, much less did plaintiff herein sign his ticket when he made the flight on November 23, 1959. The court holds, therefore, that the appellee is not and cannot be bound by the conditions of carriage found at the back of the ticket stub issued to him when he made the flight on appellant's plane. It having been clearly found by the trial court that the transistor radio and the camera of the appellee were lost as a result of the negligence of the appellant as a common carrier, the liability of the appellant is clear. It must pay the appellee the value of those two articles. Significantly, in the case of Ismael and Co. versus Barreto, cited by the trial court in support of its decision, this court had laid down the rule that the carrier cannot limit its liability for injury to or loss of goods shipped where such injury or loss was caused by its own negligence.